Our next speaker is Jason Jenkins, and Jason Jenkins is Assistant General Counsel in the Office of General Counsel at the University of North Dakota. As UND's patent and intellectual property attorney, he works very closely with research and technology transfer and has played a key advisory role in the university's recent transition away from the controversial Fighting Sioux nickname and logo utilized by the school's athletic teams. Jason will be speaking on fair use and copyright in higher education.
That's a really nice introduction. I'm not half those things, but the applause is appreciated. Thank you. It's really a pleasure and a privilege to be here. Obviously, thank you to Kenny and Lang for inviting me. Special acknowledgement to Austin and Scott, who kind of reached out, contacted me, put this together, made this happen. And I'll tell you that UND has enjoyed a long working relationship with Kenny and Lang going back many years, particularly with Dave, who was just here. And I know we appreciate all the hard work that Kenny and Lang has done on our behalf. And frankly, if I was not up here, I would be out there because I am a regular attendee at this seminar as well. Let's see. Get the slides up. Is that on me? I apologize. So as you can see, I've got a nice scholarly sounding title here for this talk, something fair use and copyright in higher education, an evolving view from the ivory tower. It sounds all nice and poetic, but I think in all frankness, a better title might be, to make sure the font fits on the screen, but that says if you can't read it, it's the flash mob did what at the Union. And those of you, certainly in-house counsel and also private attorneys will understand the reaction sometimes that you get when your client comes to you with something that you probably weren't quite expecting. You might utter a phrase, something like, a flash mob did what? It shouldn't be a surprise that, like so many other legal issues, copyright issues are not born, they don't gestate, they just appear. And it's no different on a college campus than it is in any corporate environment or anywhere else for that matter. So we do have to be reactive and mobile and able to adapt and respond to things that obviously aren't ideal, and sometimes you just have to learn to process that. I don't often rely too heavily on quotes in presentations. Frankly, that's because of my ego. I want to be the one that you remember leaving here today. But there are a couple particularly poignant thoughts from none other than Mark Twain, and I'll just share those with you briefly. The first one is that only one thing is impossible for God: to find any sense in any copyright law on the planet. I tend to agree. The second, whenever a copyright law is to be made or altered, then the idiots assemble. And again, he had a way with words, and he was wiser than he knew, because those things are just painfully and obviously true. Some things about my role. I'm in-house counsel at a university, so I have a little bit different view of things, but so for as many things that are different, some things are the same. I call it a unique challenge, and I go by the mantra, if you will, that it's 50-50. I spent about fully 1/2 of my time trying to protect the creative output of the University of North Dakota and its faculty and staff. I spend the balance of my time trying to strip away other people's protections so that my client can use whatever the heck they want. So it really is an interesting role, and try not to get blinded by the hypocrisy of doing that. Obviously, the big component of my client are the faculty. The faculty are the ones who are, have the knowledge base and the experience and the expertise to really create, to foster creation, to foster innovation, and those kinds of things. Some of the really unique aspects of working with faculty and copyright particularly go back to the kind of the foundations of copyright law, the work for hire doctrine, which says that any work that's made by an employee within the scope of his or her employment is owned by the employer. That's just law. That's statutory. It's black letter law. It's absolute. It's immutable. You can't change it. If it's a work made by an employee, it's owned by the employer. Well, higher ed has done something that is a little It's not new. It's been in place for a long time, but there's a custom or a practice in higher ed, if you will, that we just literally turn it on its head and we say, no, Madam Professor, you own the copyright in your scholarly work. It's not a creature of law, although courts have tended to recognize it. It's seldom put forth in any contract, but it just is. So we have this unique nature of this relationship where we kind of reverse that so that our employees, several of our employees anyway, will actually own the copyright in their own works. Like I say, it's more of a policy and a custom, but it is traditionally consistently upheld by the courts. So of course we have this model where we literally default to faculty ownership as opposed to institution ownership. Again, staff are a very important part of the puzzle. The faculty are the superstars, but the staff are the people that pull it all together and make it happen. I point out the librarians because they are really the workhorses. On any college campus, if you want expertise in copyright law, you go straight to the library. The librarians have the knowledge, have the expertise, and they will get you the answer, or they will work very hard to get you the answer. And I find I give a lot of these talks on campus, and a lot of times it's to the librarians, and they're the most engaged, the most respectful, the most appreciative of all the audiences I speak to, and that's no coincidence because their role is so intimately intermixed with issues of copyright and ownership of information and things like that. And of course, the very function of a library is to distribute information. So there are a lot of interesting and fun intersections there. Another component on campus that I work with very closely is the IP and technology transfer arm of the university. It's an aside, but it bears some relevance here with respect to copyright. Across town, literally, there's litigation going on right now involving the Schwegman law firm. They've been sued by Wiley & Sons, the famous publisher, for copyright infringement. I don't know if you're familiar with this, but standard practice in patent law is you submit references, scientific papers and things, to the patent office in order to provide evidence of patentability or to comply with your obligations under law to get a patent and things like that. Well, what happens is the client, the inventor, submits their library copies to the law firm makes a copy and then sends its copy to the patent office, then the patent office in its infinite wisdom blasts it all over the universe on the web through public pair. And of course you can imagine the authors weren't too happy about that, the publishers weren't too happy about that because they view that as a breach of whatever license agreement or whatever means the original subscriber to that journal had to obtain the article lawfully. They see first, second, and third generation copying going on. The case right now is pending. I think it's at the dispositive motion stage, if I'm not mistaken. I know that the defendants have sought summary judgment. And it's interesting to see, though, because that could have a monumental impact on patent law and patent practice, because things that are very well recognized and accepted practices, I don't know anybody that was thinking about those in a copyright liability from a copyright liability standpoint. So again, keep an eye on that. And again, and Schwegman is not the only firm, but they're one of the principal ones in the biggest profile cases right now. But they really are going to pave some ground for all of us on the patent bar, and not just the lawyers, but anybody who, universities. We have journal subscriptions and we have access lawfully to these copies. Those licenses don't empower us to give a copy to our attorney and to let our attorney make a copy and send a copy and so forth. So again, it's an aside, but it's really germane to the topic and to with a link right here in Minneapolis. Again, there are others on campus that we work with. Students, of course, we can't provide legal advice to students. That's not within our scope or our ability. We do have general informational educational programs, things like that, in order to get the word out. And again, copyright is an area that there is a lot of interest, a lot of widespread interest. So again, working with students it's a lot of fun, and it's a nice way to get the information out there as well. And then the community at large. When you're in a small town like Grand Forks and you are the university, and in a lowly populated state like North Dakota, people do look to the university for guidance. So we can expect a few faces at any session we give from the community. And I think a lot of people are looking to that as, again, a means of information, although there's no shortage of information, obviously, in this day and age. So talk just a moment about how we deliver client services on campus at the university. One of, like I was just saying, is through education, through these forums, through these talks that we give all across campus. Information, providing things on the website, FAQs, pamphlets, things like that, any kind of information that the client wants. Establishing policies, this is an important one. As we'll find out in the cases that have been resolved in the last 12 months, the courts are looking to policies to see what the policies say. So I'd play an active role in establishing policy and any revisions to policies, things like that. Likewise, procedures for disclosure of information, procedures for protecting information, things like that. And fair use, which we'll get to in a moment, obviously there's a tendency to want to go with checklists, and a lot of people like the notion of a checklist to make sure they're doing all the things and crossing the I's and dotting the T's, so to speak, and with respect to making sure they have a good fair use claim. So checklists are one of those things. Of course, last but not least, legal opinions, which again is a big part of what I do. And I put it proactive and reactive. Obviously, proactive is nice, but again, as we all know, that doesn't happen. Things don't come up because we plan for them. Things come up because we have to react to them. So a big part of our role is to be reactive, to be responsive, and be prepared for those kind of things when they do happen. Although I'd love it if everybody would come to me and get an opinion, because it would keep me busy and keep us out of trouble. So there's some unique issues in higher education. One of them is copies for classroom use. We've all been in class and had things handed to us. Well, that's implicating somebody's copyright and whether or not there was adequate permission to do that. Electronic course management. If you've gone to school recently, and this doesn't include me, almost everything about your course is managed online. There's an interactive portal. You get your syllabus, you get your assignments, you turn in your assignments, you get your grades. Everything is facilitated in most courses and many departments electronically, online. Digitization of special collections in the libraries. This is near and dear to my heart. I've worked with Dickinson State University, that is the proud home of the Theodore Roosevelt Center, and they are working very diligently to digitize a mammoth collection of Theodore Roosevelt's papers from not just his presidency, but also his life in general. And there, as you can imagine, there are potential copyright issues involved in digitizing. Public performances. We bring a lot of entertainers to campus. We put on a lot of things on our campus, all of which you have to at least address the copyright issues there, and we do that through contracting. We have performance agreements. We make sure that we maintain the necessary licenses as an institution so that people can come and perform music on the stage without infringing some songwriter's copyright, for example. Again, that includes live music, our sporting venues, between periods or between plays at the arena, they're playing music. And again, that implicates somebody's copyrights. Those are things that we have to address, obviously, as an institution. Common areas in the residential halls. You'd be surprised by the number of questions I get about, can we show a movie on the lounge in the dorm? And there's an interesting doctrine in copyright law about whether or not it's a public performance, and you look into who can be there. So those kind of things that also come up. File sharing is the big bad one. The Recording Industry Association of America, the RIAA, got into its head some time ago that it was going to embark on a campaign against individuals for file sharing, and they filed several lawsuits. They got all kinds of settlements through different means. And so again, and because of the nature of who college students are at that age in their life and the willingness to adapt to new technology and share things, obviously college students were really singled out as a bad actor, if you will, in the file sharing era. Flash mobs and viral YouTube videos. If you're young, you know what these are. If you're not, you're like, what is it? Flash mobs are just simultaneous, spontaneous, erupt into dance in an unusual or odd public setting, such as a mall, such as a library, such as a public quad, anywhere. A lot of people might get together and plan this, but they'll just erupt spontaneously into a dance, into a song, something like that, and invariably there's somebody recording it, and of course it makes it onto YouTube where it becomes a viral video, and of course viral just means it spreads like wildfire. Interesting one, I don't know if you're familiar with this, it happened earlier this year, but time flies so fast, this seems like old news, but it's called the Harlem Shake. It was a little snippet of a song, and it got adapted by some people who thought, we're gonna have some fun with this. And they put together a video, and it's part flash mob, part video, because it's a spontaneous event, as you'll see, but it's recorded and it's obviously intended to be spread by word of mouth and things like that. These occur at team practices, locker rooms, sporting venues during games. Literally, they'll get the entire student section at a basketball arena on cue, and they'll do this during a particular timeout or something like that. And again, these things happen in dorms, libraries, and common areas. Go on YouTube, search, you'll find it. You can't miss it, actually. And for your benefit, hope we have some volume here. Not getting the sound, I apologize for that. So anyway, You get the spontaneous part anyway. And this is an example of a part flash mob, part viral video. The Harlem Shake is a musical piece where it starts off kind of slow, and one person in the frame will be dancing. And then at a certain point in the snippet of the song, the tone changes, the beat changes, then everybody, and people who weren't even in the frame before, will suddenly emerge in a wild dance. So of course you've got a very recognizable figure in these parts, doing a dance there. I assume that's on the campus over at the U, and there you go. And this is the Harlem Shake. And I got to give a shout out to the gentleman that put this together. He very willfully gave me permission to use this here today. But as you can see, these do, I mean, here you've got Goldie, is it Goldie the Gopher? You got the Gopher out there, front and center, doing this is our image, this is our identity to the public. So that's why these things are so important. Another one that's even a year older, so it's ancient, Call Me Maybe, the song by Carly Rae Jepsen. Out of nowhere, somebody decided they were going to do some improv, some dancing. They were in a team van probably coming to or from a game, and it was the Harvard baseball team that started this. And don't think that these don't have impact. That video on YouTube has over 17 million views, and they make no secret that they are the Harvard baseball team. So as you can imagine, in higher ed, we look at this as maybe cause for some concern. So there's certainly some issues to be considered there. The law is on our side. And it's not just on my side, it's on everybody's side. We'll kind of point that out. First of all, you have fair use. Fair use is provided for in the Copyright Act. You know, it kind of sets the boundaries, and we'll get into that in a moment. And fair use is available. That's the one that's available to everybody, not just higher ed, everybody. Higher ed does have a few privileges, though. We have a section of the Copyright Act for libraries, for some of their unique functions. We have an exception for face-to-face teaching. We have an exception for distance learning electronically. We have a cap or a bar on statutory damages. If a university acts in good faith and thinks it has a good faith case and is wrong, a plaintiff cannot recover statutory damages under this particular provision of the law. So we talk about what are the defenses to copyright infringement. You made the mistake. What are you going to do? What do you have to point to? The first one is, of course, you made a non-infringing use. Second one might be independent creation, but if you're playing somebody else's song, it's hard to make that one with a straight face. You can try to invalidate somebody's copyright. There's a kind of an esoteric defense of misuse. Abandonment, that's another tricky one to prove. So we'll just really spend most of our time focusing and talking about the non-infringing uses that really make up the crux of what we see on a regular basis and what we do and what we teach and try to have people do. First one is hyperlinking. Everybody wants to share. Sharing on the internet has become is the mode of communication, and hyperlinking is the great equalizer there because it's not copying. If you link to something, you send somebody the link and they go and access it on the web, you're not copying it, you're not distributing it, so it's much better for the person who's sending the link. You want to make sure the site or the target that you're hyperlinking to is authorized, hopefully legitimate. You know, you want to put out some effort to make sure it is. If it's a New York Times article and it's on Jim Bob Bo's website, that might be a question. You want to make sure you're pointing to the New York Times website instead. Obviously, you want to, whenever possible, you want to point to the source. And it's like I say, it's a very good alternative. Not only does it save you the trouble of cutting, pasting, scanning, uploading, you just send the link. Now, links, of course, get broken. Links sometimes go bad, so there is a downside of that. But again, I think the upshot of hyperlinking is far worth the minimal downside. Another non-infringing activity is to try to stick with things that are in the public domain. Public domain is tricky to identify. I'm going to blow through these. Just so you know, there are many categories or classes of works that are in the public domain. One is most primarily through the expiration of copyright. And you see, there's just a whole slew of circumstances that could lead to a copyright expiring. And of course, because copyright is limited in time, they all had reference to a year, and you can see that in the materials. Public domain, a work can end up in the public domain by being invalidated by a court. Anything by the federal government, this is something that maybe a lot of people don't appreciate. The federal government cannot, by law, hold a copyright in its own work. So if it's done by a government employee, it's fair game. You can do whatever you want with the IRS, with any of your favorite federal agency, and they can't sue you for copyright infringement. That's the good news. Be careful, though, because if it's a contractor done for hire, if the federal government issues a subcontractor a contract, and they have a contractor prepare something, then that rule doesn't apply, and then there can be a copyright on what otherwise would seem to be a federal work. A work can be dedicated to the public domain expressly by the author. I would warn people, though, that historically, the courts have not embraced this. They're looking for proof. They're looking for absolute clear proof. So unless you have something that will really hold up with respect to the giftor, the author, you might want to shy away from that. Also, legislatively, the trend has been to extend copyright protection. Term restoration legislation comes to be when you hire somebody named Sonny Bono to be, when you elect somebody like Sonny Bono to be your legislator, your representative in Congress, they come up with these bills to protect the creative arts. And that's exactly what happened during Representative Bono's time in office. You actually had a bill with his name on it that was some term restoration legislation that rescued or captured some works that had gone into the public domain and roped it back in to be within the copyright. There's been a significant move in the last century to remove the formalities. There used to be, you had to work to get a copyright. You had to file, you had to register, you had to renew, things like that. You had to put notice on there. Not anymore. Copyright is automatic. These things don't apply anymore, so you can't rely on those types of oopses by the copyright holder to make use of their stuff. And also you see, on an international basis, you see a very liberal adherence to treaties and foreign law. Basically, we're a signatory to most of the key treaties in this area, and if the other countries are signatory, you're going to see an outcome that is very tilted in favor of the creator, of the copyright holder. I mentioned earlier the statutory exemptions we have, the teaching exceptions, just go through those briefly. Section 110.1 of the Copyright Act, this is the face-to-face teaching exception. This basically says if you are an educational institution, if you are an educator, anything you do in the course of face-to-face teaching, typically in a classroom, but it could be somewhere else, is going to be immune from copyright. It would not be copyright infringement, for example, for a music teacher to perform a work in class with her students. It would not be an infringement for a history professor to show a film in class to his students, those kind of things. Limitation, it is, when they say face-to-face, they mean face-to-face. This does not apply. You cannot apply this section of the statute to electronic streaming, such as distance learning, which in my neck of the woods, distance learning and what they call the MOOCs, the massively open online courses, and basically the theory is that these will totally revamp how education is delivered. This would not be the vehicle to do that, but it's just for face-to-face teaching. And because it's location-specific, it's a classroom or a similar place devoted to instruction, so you can't just use it carte blanche however you want. The corollary to this, or the partner to this, is Section 110.2. And this was called the TEACH Act. And this basically, in recognition of some of the emerging media in the maybe late 90s or so, Congress recognized that we need to make some of these things adaptable so that educators can still teach in the new media, but without having the copyright consequences. So it does exempt certain performances by government bodies and accredited nonprofit education. Now there's a carve out. If you're a for-profit institution such as the University of Phoenix, you can't avail yourself of this statute. And it does have some other interesting features, especially in comparison to the face-to-face. It's the electronic transmission of non-dramatic literary or musical works and reasonable and limited portions of any other works, including motion pictures. Now, the reason I point that out, it's so important, is that that limitation doesn't exist in 110.1. It doesn't exist in fair use. It only exists here, reasonable and limited portions. So again, the usefulness of this statute is debatable. Another limitation, it must be directly related and a material assistance to the teaching content. It can't be for fun. It can't be for minor amusement. It has to have this direct relation to the teaching. Again, a limitation you don't find in fair use. You don't find in the face-to-face exception. Another limitation, more baggage, the copy must have been lawfully made. Not that we deal a lot in bootleg copies, but Congress thought to put this in here. And again, not a limitation you'll find in fair use and not a limitation you'll find for face-to-face teaching. Limited to officially enrolled students. There's more. The institution must have adequate policies in place. You have to describe and promote compliance. You have to provide notice of copyright protection. You have to have the latest and greatest technology to prevent capture downstream so that, let's say it's a stream, but it can be viewed but not downloaded, those kind of things. So again, the video or the distance learning exception under 110.2 is not nearly as useful as 110.1 and certainly not nearly as useful as fair use because of all the limitations it imposes. Fair use, that'll dominate the rest of what we're talking about here today, and it is certainly legitimate because it's a very important topic. Fair use, the statute is actually very, very simple, and it's easy to read, you digest it. There's 4 considerations, there's 4 factors in fair use. One is the purpose and character of the use that you want to make. For example, is it commercial or nonprofit? Second is the nature of the work. What is the work that you want to use? What is the amount of the work you're going to use? Are you going to use the whole thing? Are you going to use a portion? And fourth, what is the effect of the use that you want to make on the market value of the work? And these are the subject of infinite debate, and we'll kind of plow through them a little bit, but that's it. That's fair use. There's nothing about reasonable and limited copies. There's nothing about authorized face-to-face, distance, none of those. This is the focus, I think, and it's where the analysis, in my opinion, should start, because if you can get there in fair use, you don't have to worry about the 110.1s in the world, you don't have to worry about the 110.2s, you don't have to get a license, and all that good stuff. Congress was also very gracious. They enumerated several purposes for fair use right in the statute, and I'll point out the last 3. Teaching, scholarship, and research. You think, wait a second, why does that sound, university? Clearly, Congress had the utmost intent to get fair use squarely within the confines of a campus, of a school setting. And you can't debate that because it says right there in the statute, teaching, scholarship, and research, which are 3 of the fundamental core activities at a university, certainly. I say fair use is allowed. There's no liability. You don't have to pay royalties. You don't have to get permission or a license. Catch is it can be a tricky fix to figure out whether or not the use you want to make is fair use. It's very subjective, turns on the facts of every case. You won't get a lot of guidance from the case law because all the courts come out and say, well, every case must be judged on its own. So there's very few hard and fast rules. You're kind of left on your own. Fair use is not carte blanche. Fair use is not, it's a very useful tool. It's like a muscle you want to exercise. You don't want it to atrophy. You don't want it to go away. But there are limitations. You have to balance interests. It's about equity. It's about fairness. The bigger kicker is over time, there were really no mathematical formula. There are no rules. Again, you have to make that subjective determination almost in every case. And this is where it got interesting in 2012 because there was very little information or guidance in the case law. There's very little instruction for us or anybody else to evaluate fair use, and especially as things were evolving, and I say the new technologies, the new media. And as we'll see, in 2012 was a gift year because there were 3 cases decided squarely in this field. The first was Cambridge University Press versus Becker, a group of academic and textbook publishers, Cambridge, Oxford, and Sage. You'll notice 2 of those plaintiffs, Cambridge University Press, Oxford University Press. That's important. They were backed by the Copyright Clearance Center. Basically, that is the clearinghouse whom we pay hundreds of thousands of dollars every year in royalties and subscription fees to access academic journals and literature. And this group, funded with basically university money, including university publishers, turned around to sue Georgia State University. The focus of the case was the e-reserve practices at Georgia State's library. Interesting, strategic move here. They named several individuals as defendants, including the president of the institution, the provost, the dean, members of the board of regents individually. They didn't identify they didn't sue the university. They sued all these people. And I wonder if that wasn't for harassment value. To name all these people who had varying degrees of involvement, but certainly, and the court procedurally, the court was able to dispense with a lot of those claims. In the lawsuit, the plaintiffs, the publishers, identified over 100 works. Georgia State went at this, and to their credit, they fought, and they fought hard. It was a long and expensive battle for them. They asserted their fair use defense. They did have a policy. They admitted and acknowledged that it was not perfect, but they stuck to it. The court made several key findings. First of all, that fair use did apply to e-reserves. Again, this might be the first case where a court has looked at current contemporary e-reserve practices and said, yeah, that's okay. Court ruled in the defendant's favor on all but a handful of works. I think maybe there were 5 out of the 100 and some that the court said, yeah, that there's infringement. Again, this is, I'm pretty sure this is the first case in which a court has looked at this issue from this standpoint, and certainly in the university context. As you can imagine, everybody was watching this case. This was one of the more watched copyright cases, certainly that I'm aware of in the last few years, and on both sides, because the publishers, the publishers recognize revenue losses, and they're trying to find out new and interesting ways to make money. The court, she did her job. The district court judge, the opinion is probably 350 pages. She thoroughly analyzed each and every work. She applied the fair use factors to each and every textbook. She basically shot down the attempt to remove e-reserve practice from the scope of fair use. Of course, the plaintiffs wanted to narrowly restrict fair use. The court said no. She did note that for purposes of the third factor, this is the quantitative factor, how much, she said that decidedly small did favor the user, but again, there's never been a pronouncement that you can't use all. Matter of fact, there are several cases where use of the total work is still found to be fair use. In this case, the Georgia State case, the court said there was no upper range, but she did say that 18.52% was close. So she was looking at this quantitatively, which I think was against the weight of the authority and the weight of the precedent. But so be it. She did. She made a thorough analysis, came up with a very well-reasoned opinion, and again, these quantitative guidelines. She did kind of enunciate some quantitative guidelines that could be used as guidance, I suppose. She said up to 10% of pages of a book with fewer than 10 chapters, or up to one complete chapter for a book with more than 10 chapters. So you got this quantitative objective threshold, which some people like. But like I say, this is not a conventional, and it's certainly not something that I don't think anybody was, on the fair user side was advocating for a quantitative approach to fair use. The court did award the university its attorney fees and costs. Case is now being appealed. I look at this case as helpful guidance. It's limited in scope. It's e-reserves. It's just a district court opinion for now. But at the same time, we're going to keep an eye on the appellate process and see how this turns out. Are we going to, or are all institutions going to have to adapt or modify their policies as a result of this case? The second big breakthrough last year was the HathiTrust case. HathiTrust is a nonprofit that got hooked up with Google, and Google, of course, is no stranger to controversy, and they're embarking on a mass digitization, a Google Books project. The goal, of course, is to have all books, well, as many books as possible, I suppose, archived, searchable, and accessible. This third part is important, the accessible to persons having impaired vision, because it really sheds light on why the court did what it did. So the authors, an authors guild, a group of authors sued the HathiTrust and participating universities, and they alleged copyright infringement. They said, you're digitizing our work. We didn't give you permission. You can't do it. Again, the defendants assert fair use. The court found the project goals were primarily transformative use. You'll see that concept a lot in copyright law, transformative use. A transformative use is one that kind of deviates a little bit from the original intended use. And it typically favors fair use because you're not doing the same thing that the author did. You're adapting it or you're applying it in a slightly different way. The court recognized, this is interesting, that it's sometimes necessary to copy entire works. Now you've got an about face. You've got the court in Georgia State saying, less is better. But here's, this is the great weight of authority in line here that is sometimes necessary to copy entire works. The court was not impressed by the plaintiff's complaint that they were losing licensing revenue. And there's some great snippets from the court. I wouldn't have said this better myself. The totality of the fair use factors in this case suggest that copyright law's goal of promoting the progress of science would be better served by allowing the use than by preventing it. The public derives tremendous benefit and authors stand to gain very little if the public is deprived of this resource. Although I recognize that the facts here may on some levels be without precedent, I am convinced they will fall safely within the protection of fair use. I cannot imagine a definition of fair use that would not encompass defendant's work. I don't know that you can make a better statement of, one, the law, or two, the relief and the realization that what we're doing is okay, and the courts seem to be inclined to back us up. Of course, granted judgment for the defendants. Again, it's only a trial court case. It is also being appealed, but it's another great example of applying fair use, the old doctrine of fair use, to real-world activities, digitization in this case, that have a direct impact on higher education, especially in the library function. Again, I would say that it's no surprise that everybody's paying attention, and the publishing industry and authors are definitely paying attention. It may have an impact on future litigation. I point out the Google case is ongoing. Google, you may have heard a couple years ago there was a settlement reached, and then the court eventually kicked out the settlement. So the Google Books case goes on, but we at least have that part of it, the nonprofit, the educational arm of the Google Books component seems to be resolved squarely in the favor of fair use. The last case I'll point out was AIME versus UCLA. These were educational video producers, Ambrose and the Association for Information, Media, and Equipment. They sued the California Board of Regents and the chancellor at UCLA, alleging that the licensed DVDs, so these were legitimate DVDs, the university had a license, but the university copied that and then distributed it and streamed it online for its students. Defendants, of course, moved to dismiss, again, asserting fair use. That motion was granted. Court first found that the association lacked associational standing to bring the case. This is, when you see these cases brought on behalf of the Authors Guild and these associations, this is a critical procedural component of the litigation because a lot of times they can't make the necessary showing to even bring the case. And of course they're not going to get in, well, it'd be difficult because sometimes the copyrights are so disparate, it'd be hard to, to get the individual plaintiffs on board. So when you have these associations bringing the case, maybe it's more palatable to the publishing industry that's backing these cases. First of all, the court found the sovereign immunity protected certain of the defendants. Qualified immunity, basically that a reasonable person would not have known that the conduct they were engaged in infringed the copyright. So again, there's some non-copyright doctrine that plays very well into the hands in the UCLA case. There was some ambiguity as to whether fair use applied. And the terms, conditions, and license agreement were ambiguous. So it's funny because the publishers who should be in the position of drafting the most watertight license agreements were kind of hoisted on their own sword here because I think the court was looking for anything in that license agreement defined as faulty or defective so that so that the court in this case could reach this outcome. Certain of the activities were basically licensed already by the terms of the license, and you get into some of the technological aspects of, copying memory, a temporary use copy on a computer and then uploading and what happens. But the court found the copying was incidental fair use. The copy had to be created to upload the content for streaming. Streaming is not distribution. This again is a kind of more of a technological but a key distinction. There was the Digital Millennium Copyright Act, the DMCA, had an anti-circumvention clause that said you couldn't get around technological measures in order to access something, but the court didn't find that in this case. The defendants in this case had lawful access. They had a license. They had permission to own and use that DVD and to use it in educational purposes, and the license was ambiguous as to whether or not online streaming was different than teaching. And so again, and perhaps most surprisingly, these were dismissed with prejudice. And this was, I don't know if there was ever as much momentum in the UCLA case, but it certainly didn't have the long procedural life as some of the others. But still, nonetheless, the outcome was very favorable for those of us in higher ed. I think for all of us, because again, I used the analogy earlier of a muscle and exercise. And I tell this to people on campus all the time, including the librarians who I spoke so highly of. Librarians are a great group of people, but they are so conservative. Librarians might be the most conservative people you'll ever come across. They don't like to go down this road. They want to do whatever they want to. They want to make sure the licenses are in place, everything is done. But we have this dialogue about making use of fair use. You've got to exercise that muscle. The worst thing that could happen to any of us, I think, is that we wake up someday and we've lost fair use. Fair use is so important to so many things, not just on a college campus. I'm a strong advocate for using fair use. I think you have to keep pushing those boundaries. And I mean, even as we saw in the music case, the RIAA, they eventually stopped the lawsuit campaign. I mean, they can only extort $3,000 settlements from so many people, right? And they were taking a horrible backlash in the public image, and the perception of the industry went down the tubes. So you don't see the RIAA mounting those lawsuit campaigns anymore. So again, maybe fair use is maybe it never went anywhere. Maybe it's resurgent. But I think the fact that we've had these 3 cases come down in the last 12 months is so critical. It's certainly how we go forward. Biggest question we get, obviously on a campus and probably in some of your offices, is can I use it? It's a loaded question. I would say based on what we just talked about, things are looking up. E-reserves, we know in the Georgia State case that we know that at least up to 10% or 1 chapter will always be okay. Digitization, HathiTrust case clarifies that transformative uses, they get the green light. Streaming, in the UCLA case, we found that courts will strictly construe the existing licenses. That's a big one because, again, those things are tilted so heavily in favor of the licensor. And that fair use can be ambiguous. And the court recognized that people have trouble applying some of these concepts and that qualified immunity is available if nothing else works. There are really only 2 safe harbors when we talk about copyright. That's it. One is to get permission, and the other is not to do it, not to make the use. Everything else is a risk. Fair use is a risk analysis. That's what it is, boiled down to its basics. You have to manage those risks. You have to ask yourself, is it worth it? Does the risk Do the rewards justify the risk? Are there alternatives? Is there something in the public domain we could use instead? This is actually an interesting topic, and if you're not familiar with, over the last several years, we've seen a dramatic increase in the amount of content, the amount of information that's released under what's called a Creative Commons or a GNU or a similar, there's this notion of open sharing of information that's really been born probably in maybe the last 10 or 15 years. And it's gaining momentum, it's growing. So you're seeing a lot more content out there that doesn't have the constraints of licensing and the threat or the specter of infringement, because it's released, the creator says, have at it, world. This is Creative Commons. You can do whatever you want with this. You might not be able to do it commercially, but you can do anything else. So we talk about getting permission. That's a fairly straightforward process, usually by way of a license. You usually pay something along the lines of upfront licensing fees or maybe royalties. I had this thought going in. I've been at UND for 4 years now, and I thought when I went to people to ask permission for stuff, they were going to say, sure, why not, go ahead, little school on the prairie, do what you want. Not the case. The first copyright license I tried to negotiate, I knew I was hosed when they put me on the phone with a Park Avenue, New York attorney, and I thought, this is over. I mean, they probably spent more on that phone call than we would have ever paid them for a license fee anyway, but I don't know. And it's a process, it's a negotiation process. This is important. I would like everybody to know this about fair use. The fact that you try and fail doesn't hurt you. The fact that you entered into negotiations with a copyright holder and didn't get there, you didn't like their price or whatever their terms, it doesn't prevent you from making a fair use claim. You can still assert fair use. If you don't get the deal and you use it and they sue you, you still have fair use at your disposal. Downside is you're on their radar screen. They're going to know, they're going to be looking maybe to see if you try to make that fair use. But again, it doesn't hurt to try. As higher educational institutions, a lot of us already have it. We maintain institutional licenses. In music publishing, the three amigos, ASCAP, BMI, and CSAC. These basically control the vast majority of all published musical compositions. And because we have licenses, we already have certain rights to make use of those works. You can have subscriptions with publishers, content aggregators. You know, it's not that you don't buy subscriptions to a single journal. You buy them from a content aggregator, so you have electronic access to a whole suite of titles and publications, things like that. This is an oldie but a goodie, and I think nowhere more does it ring true than copyright law, that it is easier to beg for forgiveness than to ask for permission, and I think that embodies fair use. A fair use assessment can be really, really simplified. Ask yourself, what is the nature of the work to be used? Is it commercial? Is it popular? Is it mainstream? Is it factual? You know, is it the latest hit from Lady Gaga, or is it something from some obscure thing from the 1930s or 40s or 50s? Something like that. What is the nature? How do you want to use it? Do you want to make a commercial use of it? Yeah, that's dangerous. Nonprofit, you're looking better for fair use. Educational, again, is always looking good for fair use. Proportionality, how much are you going to use? Are you going to give attribution? Are you going to give credit? You know, it wouldn't make much sense to try a fair use and then not give credit, you know, to at least acknowledge. And then are you making a transformative use? Are you doing something in a different way? Are you giving it a new expression or a meaning? Are you giving it new insights or understandings? As the court found in the HathiTrust case, are you preparing something for access by the blind, by the visually disabled? Are you making something accessible to them they couldn't have otherwise? That's a transformative use, and I think the courts will continue to embrace that. We talk about building a good faith case. Maybe the mystery fifth factor, kind of like the fifth beetle. The fifth fair use factor is good faith. It's your behavior. How are you as an actor? Are you making a good case? Did you put forth any effort at all? I mean any effort to figure out who the rights holder is. It's hard to do. There's not a one-stop shopping for this stuff. Music is the one exception because the aggregation of those rights and those publishers, ASCAP, BMI, and CSAC, that's reliable. You can find out who owns the rights in those works. Movies, almost impossible. You know, you'd be amazed how many hands a motion picture will go through from the time it's a screenplay, well, heck, from the time it's a novel, an adaptation, a screenplay, a film, distributed in the theater, distributed on home video. There could be easily 6 to 10 entities that claim a right in that motion picture. So, and there's no nationalized database of motion picture rights. Buy an authorized copy. Back in the VHS days, it was hard to get a good quality. You would never make a copy of a VHS tape because it was crappy. But, you know, obviously, I'd much rather be in the position of arguing fair use if I at least went to the store and bought a CD. That's how old I am. Or, you know, at least paid for my copy on iTunes. You know, that's the kind of stuff that, again, builds that good faith case, that fifth fair use factor. I point out at least somebody's getting paid. I think it takes a little bit of the fire out of the argument if the artist got paid. Obviously, you want to document those things, get a legal opinion. Hey, that's what we're here for, right? Legal opinions are excellent evidence of good faith. I think that any court would look favorably upon a user who at least tried to apply the law. Some narrow limitations or some small limitations for legal opinions. They have to be bona fide. They have to be prepared by competent legal counsel. That's not a surprise. Preferably in writing. I think that it'd be hard evidentiary-wise to prove up, yeah, I talked to my attorney, he said it was okay. The advice of counsel defense does not excuse infringement, but it may limit the remedies. You're not going to get hammered, in other words. If there's damages, you're going to be on the lower end. So you can avoid the increased statutory damages and attorney fees. That's a plus. The caveat here, of course, is that you're basically jeopardizing the attorney-client privilege, and the client absolutely has to understand that what the attorney told them is going to be used against them. So if the attorney said, yeah, I don't know, you may want to do it this way, and they don't, then obviously the advice of counsel defense, you want to be careful with that. Because I work at an educational institution, I think I'm obligated to test you now. I want to see how close you were paying attention earlier. So we're going to work on some terms, some terminology. A little visual association. Anybody have a guess what this might be? Flash mob, very good. Anybody? Viral video, very good. And the last one, any guesses? Is a copyright lawyer. But for full credit, I would have also accepted non-university employee. Thanks again to the folks at Kinney & Lang for having me. You've been a great audience. Thank you.